is an independent national human rights institution established under Article 59 of the Constitution of Kenya, and also as captured in the Kenya National Commission on Human Rights Act. Our mandate is principally to promote and protect human rights in Kenya, and under the Paris principles relating to the status Okay, thank you very much. We are here to address the issue of the attacks on the civic space by the defunct NGOs Coordination Board. And would like to state that the Kenya National Commission on Human Rights is an independent national human rights institution, and we are established under Article 59 of the Constitution of Kenya and under the Kenya National Human Rights Act of 2011 as revised in 2012. Our mandate as a commission, as a national independent commission, is to promote and protect human rights in Kenya. And the Paris principles relating to the status of national human rights institutions require organizations such as ourselves, commissions such as ourselves, to develop relations with non-governmental organizations devoted to promoting and protecting human rights. The Commission has noted with grave concern the ongoing intensified assault on the civic and democratic space by the now defunct NGO Coordination Board headed by Fazul Mohamed. The latest attacks target AFRICOG, or Africa Center for Open Governance, and the KHRC, the Kenya Human Rights Commission, which are two of the leading NGOs in the human rights sector in our country. Yesterday, the NGO Coordination Board accused the two organizations of financial and regulatory impropriety and called upon the Kenya Revenue Authority, the Directorate of Criminal Investigations, DCI, even the Central Bank of Kenya, to take adverse actions against them, including freezing of their bank accounts and arrest and prosecution of AFRICOG directors and members. Fazul directed AFRICOG to immediately cease operation and asked the Director of Immigration to deport all foreigners working at KHRC. To the best of our information, there are no foreigners working at KHRC. And this morning, officers of KRA accompanied by the police arrived at AFRICOG offices with a questionable court order seeking to conduct an operation pursuant to Fazul's operative directive. The operation was called off following protests from AFRICOG and a directive from the acting cabinet secretary for Ministry of Interior and Coordination of National Government, Dr. Fred Matiang'i, and we wish to commend this action. Both the KHRC and AFRICOG have told us, the Kenya National Commission on Human Rights, that they were not given an opportunity to respond to accusations, which is a breach of the right to fair administrative action and fair hearing guaranteed under Articles 47 and 50 of our Constitution, respectively. Further issues raised against KHRC have been determined by the High Court in a petition, and particularly petition 495 of 2015, in which the court found that the NGO Coordination Body had violated the KHRC's constitutional rights. In fact, the High Court declared, and I quote, "The adverse actions taken by respondents," that is the NGO board, "in commencing the registration of the petitioner, the KHRC, and further ordering the freezing of the petitioner's bank accounts is unconstitutional, null, and void." By bringing the same accusations that have already been heard and dispensed with by a competent court, instead of appealing that decision, makes the NGO board or put the NGO board in direct contempt of court, which is illegal and against the principles and values of our Constitution. The Kenya National Commission on Human Rights recalls a similar attack on IFES, or the International Foundation for Electoral Systems, in December 2016. And on 19th December last year, Mr. Fazul issued a statement purportedly terminating the Kenya Electoral Assistance Program coordinated by IFES on the basis that IFES was not registered and was therefore carrying out activities illegally in this country. He advised the Central Bank of Kenya to freeze all IFES bank accounts and advised the immigration authorities to investigate the working status of Mr. Michael Yard, the IFES director. IFES has since proved that it is legally registered in Kenya by the Registrar of Companies and has actually been operating in this country since the year 2002. In April 2015, following the terrorist attack on Garissa University, the Inspector General of Police issued a gazette notice listing a number of organizations that he intended to classify as specified entities associated with terrorist groups, which included Muhuri, or Muslims for Human Rights, and Haki Africa. The government proceeded to freeze the bank accounts, thus halting their operations without affording them adequate opportunity to be heard. It's worth noting that at the time of this listing, the two organizations were very outspoken and seeking accountability for human rights violations by security agencies in the war against terror. The two organizations filed a High Court petition in Mombasa, citing violations of their constitutional rights. And just like KHRC, in the petition mentioned above, the court found in favor of the two organizations and found the actions of the IG of police in gazetting the two organizations and freezing their accounts unconstitutional, illegal, and hence invalid. The court found that that action was null and void ab initio. The judge in that particular petition concluded that the petitioners' rights to fair administrative action afforded them by Article 47, Subarticle 1 of the Constitution of Kenya were violated by the publication of the Gazette notice. It was tainted with procedural impropriety for failure to afford the petitioners fair administrative process. Despite the judiciary's pronouncement on the unconstitutionality and illegality of these actions, the NGO Coordination Board, through Mr. Fazul, continues to issue arbitrary and illegal directives, particularly targeted to civil society organizations perceived to be critical of government. This is an acceptable impunity for a state agency which is bound by the Constitution to abide by the rule of law, transparency, and accountability. The Commission is further concerned by the persistent failure of the government to operationalize the Public Benefits Organizations Act that was passed and assented to in 2013. The High Court petition number 351 of 2015, where we, our commission, appeared as amicus curiae, declared that the first respondent, that is the Minister for Planning and Devolution, to appoint a date for the coming into operation of the PBO Act 2013, the failure was the failure of the minister or the Minister for Planning and Devolution to appoint a date for the coming into operation of the Public Benefits Act was in violation of Articles 1, 10, 73, 94, 116, Sabbatical 2, 129, and 153, Sabbatical 4 of the Constitution of Kenya, 2010. Consequently, the court on 24th November 2016, last year, issued an order of mandamus compelling the minister to operationalize the act within 14 days. This order was not complied with. Instead, the President immediately transferred the function of regulation from the NGOs from the Ministry of Devolution and Planning to that of Interior and Coordination of National Government. This transfer was irregular as the Section 2, Subsection 1 of the Public Benefits Organizations Act places the public benefit organizations under the Ministry of Planning and Devolution. Our commission views this transfer as a scheme by the executive to frustrate and circumvent judicial orders through administrative powers. On 20th December 2016, our commission, together with the civil society partners, moved to court seeking orders that the Cabinet Secretary for Devolution and Planning and/or the Cabinet Secretary for the Ministry of Interior and Coordination of National Government be cited and held to be in contempt of court. On 12th May 2017, the court found that A, the Cabinet Secretaries for Ministries of Devolution and Interior had willfully disobeyed a valid court order. The High Court ordered the Cabinet Secretary, Ministry of Interior and Coordination of National Government to comply with the above judgment within 30 days from the date of service of the order to comply with the judgment of number 351 of 2015, which I have mentioned above. He will be liable to be committed for contempt. Ladies and gentlemen, over 60 days have lapsed and the Cabinet Secretaries have persisted in defiance of court orders by refusing to operationalize the Public Benefits Organization Act. This level of impunity at very high levels of government is appalling and gravely undermines the rule of law in this country. The rule of law requires that orders of court be respected and obeyed. Willful and flagrant disobedience of court orders undermines the authority and dignity of the judiciary. The Kenya National Commission on Human Rights is of the considered view, therefore, that the NGO board continues to operate illegally, as the NGO Coordination Act is no longer in operation, having been replaced by the Public Benefits Organization Act of 2013 as per Article 116, Sabbatical 2 of the Constitution of Kenya. We call on the Acting Cabinet Secretary for Ministry of Interior and Coordination of National Government, Dr. Fred Matiang'i, to operationalize the PBO Act forthwith. Continued delay will only serve to create more uncertainty in the sector and perpetuate the illegal conduct of affairs by the defunct NGO Coordination Board. Our commission joins the Law Society of Kenya in reminding the Cabinet Secretary of the consequences of disobeying a court order. Those in power must lead by example in adhering to the rule of law, otherwise they encourage ordinary citizens to defy the law, leading us to anarchy. Further, our commission reiterates our concern that Fazul Mohamed continues to hold public office despite being declared unfit to hold public office following the investigations by the Commission for Administrative Justice for abuse of office and misconduct. The Commission on Administrative Justice also established that Mr. Fazul was irregularly appointed to the office, having misrepresented about his academic qualifications. We again call on the government to henceforth desist from harassment of civil society organizations and criminalization of legitimate human rights work by civil society bodies. Thank you.
So we'll take any questions that you have for us. And if also the statement was crystal clear, even the better for all of us.
Okay. Thank you very much.
They had given a memo saying that it was for officers, those in ministries. What's your take on that?
Okay, that's quite unrelated to what we've talked about here, but my comment to that is very simple. That for independent offices and the constitutional commissions, we are independent constitutions, and our independence is granted by the Constitution of Kenya. And for travel of commissioners and even staff in our commissions, we do not have to have the clearance of the head of public service, because we are independent like that. So unless there was anything else, because we are not privy to the ongoings of that particular case, that is our comment will have to be just that.
On another probably related issue, there is the issue of the violence after the election. The organization gave a figure of some of the people who had died as a result of the police action. Do you have any updates on that? And what is your take generally on some of the killings that have happened after your statement?
Thank you very much. Immediately, what we said is that we have been monitoring the state of human rights before elections. In fact, we were possibly one of the very few organizations that may have deployed monitors around the country ahead of the political party primaries. And we have been on the ground throughout the electioneering and campaigning period, up to and including the polls day on August 8th. And our monitors are still on the ground and will continue until I think towards the end of this month or sometime next month. Our observations are according to the statement that we gave earlier by the late afternoon on Saturday when we issued our statement. We had a figure of 24 fatalities. And in the first instance, we decided to just try and establish the fatalities as opposed to the number of persons injured. I would like to assure Kenyans that we continue to be seized of that particular matter, and we continue to follow up with families of the deceased so that we can establish, in as much as we can, the circumstances surrounding the death of every person that died as a result of this of the violence that erupted immediately after the announcement of the results. And we have not yet completed all our investigations, and our monitors continue to work, including our members of staff. In fact, our investigations department is headed by Commander Mucheke, who is here with us today. So we will keep updating you in terms of what we, as soon as we complete all our findings, we'll be able to speak more at length and in depth in terms of fatalities. Speculations as to whether we exaggerated the numbers are I would like to assure all Kenyans that we do not engage in exaggeration, and every fatality that we spoke about, in fact, some of the numbers have gone high. I think by Sunday we had established 4 more deaths, so the number rose from 24 to 28, and we did not exaggerate, and we do not take kindly to suggestions that we did. And we would like to assure all Kenyans that the life of everyone is important. And even if it was just one person, would still be very worried, because nobody should lose their life arbitrarily or in circumstances that are not clear. Thank you.
Perhaps you can take us through some of the changes that the PBO Act seeks to bring into the NGO sector, if implemented as it is. A summary of the changes it will bring compared to what is existing at the moment.
Do you want to handle that? Okay, thank you. Continue, just speak.
I think one of the biggest challenges that has been in the NGO sector, and which was a challenge that was recognized by both the NGOs themselves and the government, was that there was no solid regulatory framework that would hold all the public benefit organizations accountable. For example, in the past, we actually had seen cases where some of those organizations really couldn't be held accountable in terms of the work that they were doing on the ground. And I think with the coming in of a new constitutional framework, with the coming in of the new units of governance, it was felt. And I want to emphasize that this wasn't something that was started by the government itself on its own. It was something that was mutually started by the NGOs working in tandem with the government, because there was need for us to have a tighter regulatory framework that brought all public benefit organizations together, so that we do away with the concept of what we had heard about the so-called briefcase NGOs, people operating who are not accountable to anybody, and that is what we wanted to actually seal. So I think the continued non-operationalization of this act really is a disservice to the sector, because then we are not getting its full potential, as it were.
Okay, thank you. Thank you very much for coming, and we look forward to continued partnership with you, even as we serve the citizens of our country. Asanteni sana.